Yikes. I literally can't help myself because the Lally logic and the lies are incredible. So, let's get into it.
Counsel posits the question of why didn't Brian Albert come out of the house? No one did. Not only out of that house, but any house.
Hang about. How many other houses in the neighbourhood had a barely clinging to life police officer on their front lawn?
It's clearly visible in the grand jury exhibits. You have the cruiser camera footage from Officer Saraf, as far as no one else in the neighborhood coming out of the house, as well as testimony from a number of different witnesses that were there and present on that morning in the dark, in a blizzard, at the time that Mr. O'Keefe is found.
If that's the case, then where did the red Solo cups come from? But I do digress. Let's move on.
Counsel wants to say that the Commonwealth is asking the court or everybody to sort of look the other way when it comes to these things. What I would submit is that's exactly what the defendant is doing. Look the other way, defense by obfuscation. It's essentially, it's a three-card Monte trick, card trick on the corner on the side. Look at all of this, look at this relationship, look at that relationship, conflating these relationships, sort of the distortion that I would say between what exists in social media realm and what exists in reality.
Also, Lally,
the social media blogger, Mr. Kearney, who's now been indicted for intimidation of witnesses in this case.
But I do digress.
That if you know someone, that automatically means that you're best friends with them, every single one of their siblings, every single person that they've ever met or socialized with. One social interaction, transforms into a long-standing 20-year relationship, all of those things. And what
also, Lally,
from Mr. Kearney's phone, Mr. Kearney and Ms. Reed, Mr. Kearney and Mr. Yannetti, and Mr. Kearney and Mr. Jackson. They went out to lunch with Mr. Kearney following a court date.
But I do digress.
Essentially what we have is, yes, what counsel mentions is there is one expert who was given 2 extractions, presumably provided by defense counsel, that indicates from that particular FBI expert that the searches were done at 2-something in the morning.
How did the defense hand over incomplete records from the Cellbrite extraction to the feds and somehow come up with this conclusion? I would refer to the actual court document, which was filed by Alan Jackson in support of the motion for order pursuant to Rule 17 directed to Brian Albert's Verizon and AT&T, where Jackson lists the timeline of law enforcement's analysis and production of Jennifer McCabe's iPhone 11. He says the Grey Key Progress Report memorialising the forensic image of Jennifer McCabe's iPhone 11 is attached here as Exhibit L and establishes that, unbeknownst to the defence, Trooper Keefe forensically imaged Jennifer McCabe's iPhone 11 on February 2nd, mere days after the incident in question. No police reports reference the fact that Miss McCabe's iPhone 11 was forensically imaged on February 2nd. However, computer forensic expert Richard Green's subsequent analysis of that same forensic image makes clear that law enforcement has had significant exculpatory information in its possession since February 2nd, which includes inter alia evidence of Jennifer McCabe deleted a search for the phrase "how long to die in the cold" at 2:27 a.m, hours before she was reportedly aware O'Keefe was missing. Significantly, the existence of this forensic image was not disclosed to the defence, which was not produced to the defence in discovery until more than a year later. Instead, Trooper Guarino conducted his own forensic analysis of the image at Trooper Proctor's direction. Although the complete forensic image of Jennifer McCabe's cell phone was withheld from the defence, Trooper Guarino's supposedly full file system extraction report was produced to the defence in discovery on August the 12th, 2022. I have personally conducted a complete review of Trooper Guarino's May 31st, 2022 file system Cellbrite extraction report of Jennifer McCabe's iPhone 11, which purported to capture data from the 29th of January Notably, this report does not include any reference to the incriminating search made by Jennifer McCabe at 2:27 a.m. on January 29. So, how is it that the defence gave information to the feds that actually wasn't the complete information? They still don't have the complete information, although we're assuming now that they've got it from the feds, right? But I do digress.
What counsel neglects to sort of raise and stress with the court is that there's a separate, and I forget exactly what it stands for, but an RCFL analysis of the phone in which through both Axiom and through Celebrite, and that conclusion of that expert is that the searches occurred when Ms. McCabe testified they occurred because the defendant asked her to conduct those searches at 6:23 and 6:24 in the morning.
Hang about. To rebut this claim, I'm going to have to turn to Olivia's latest post, and this is shown in the evidence. Based on Jennifer McCabe's phone data and police logs, we know that Jen, with Karen and Kerry Roberts, was in the area of 34 Fairview at 6:03 and 5 seconds and called 911 at 6:03 47 seconds upon finding Officer John O'Keefe's body. Jen McCabe and the prosecution have argued that the reason for Jen's incriminating Google searches is not that she made the search at 2:27:40 a.m, but rather because she made them at the time she claims Karen Reid allegedly asked her to Google how long to die from hypothermia. But even this appears to be provably false based on the state's own cell phone extraction data and court filings. If this were true, Jen would have made those searches at 6:03:30 a.m. or specifically any time after 6:03:05 when she arrived at 34 Fairview, but before 6:03:47 making the 911 call. Jen McCabe tells us herself, based on the prosecution's own court filing, Jen claims the defendant yelled at Miss McCabe twice to Google how long do you have to be left outside to die from hypothermia, or something to that effect. Immediately upon running over to the victim, John O'Keefe, and before Jen McCabe calls 911. In order for Jen McCabe and the prosecution's story to be true, Jen would have made this Google search before 6:03:47 a.m, the time at which she called 911. But this is not what happened. Jen McCabe didn't make those Google searches until over 20 minutes later, starting at 6:23:49 a.m, at which point they were long surrounded by first responders, much better equipped for such a question. John was already loaded into the ambulance. Karen was reunited with her own cell phone, which she'd left behind mid-call in the car as she ran out to provide aid to John, which she herself could have made the searches from had she really inquired about those searches at this particular time in the first place. Furthermore, who on earth believes that the first thing Karen yells out upon finding John bloodied and dying in the cold is anything other than call 911? Jen's claim of Karen asking her to Google that is further uncorroborated by Kerry Roberts. Kerry reported hearing nothing like this, but would have similarly heard this given they were all present, and both Jen and Kerry said Karen and Kerry ran out to administer aid to John. Instead, dissimilar to Jen's account, and according to the Commonwealth statement of case, Miss Roberts stated that they immediately began CPR and Miss McCabe called 911. Karen Reid did not ask Jen McCabe to Google that, according to Kerry. The claim that that's the first thing Karen asked upon finding O'Keefe's body strains credulity, to borrow a phrase from Melanie. It further seems to be uncorroborated by the voicemail recording, capturing the audio of Karen finding Officer O'Keefe and Jen calling 911. But Adam Lally exposed the whole lie in an even more troubling way in yesterday's court hearing. Lally now states, because the defendant asked Jen to make those searches at 6:23 and 6:24 in the morning, well, Mr. Lally, not according to your court documents. According to you, and based on Jen McCabe's apparent grand jury testimony, the defendant asked her to make that search upon finding O'Keefe's body at 6:03 a.m. DA Lally must have forgotten that. Perhaps this is what happens when people aren't telling the truth. Go girl. This is exactly what I was thinking. So thank you, Olivia, for exposing that lie for us. But I do digress.
Really, the argument stops at the point of it's not, we didn't do our job to get the Cellbrite version that shows that information did not exist at the time of the grand jury. So I'm not really sure how the Commonwealth is supposed to run something through a Cellbrite version that isn't in existence at the time the grand jury is conducted.
See Karen's face right there? That's my face right now. And here's why. This is the Cellbrite website. It has all of the updates going way back. So what we'll be looking for here is this black icon. This is the full software. These are updates for parts of the software, like this is the UFED. So it's just an update for that part of the software. Now what you'll note here is it says version 7. The 0.62, the point is updates. The version 7 is the part that will change if there's a version change. So if Lally is correct, then we will go scroll back and see version 6 around when John O'Keefe's body was found. So let's just scroll back and have a look. We're looking at this black thing here. We've got 6.1, so that's an update. It's not an upgrade to a new version, it's just an update. And it's updating just some application support capabilities and some enhancements. Nothing major. Again, support capabilities and enhancements. Alright, again, it's not a version change, it's just support and enhancements. Support and enhancements. This one here in February is updating just the UFED cloud part to support iOS 15 and Android devices. But Jen McCabe's phone's 11, so that doesn't even include her phone. So yeah, we're looking still, it's not a version change. And we can go back to 2021, there's still no version change. Still no version change. So there you go. There hasn't been a change of versions, as Lally put it, at all during this whole period. There has been updates, which is denoted here after the dot. These are just updates. A full version change should have been, version 8 by now, if at all what Lally is saying is true. However, as you can see here, it's not true. There hasn't been a version change at all. Lie. But I do digress.
It's a subsequent version in which their expert, Mr. Green, finds these purported search without looking at the cache files, without looking at the DB list, without looking at the SQLite database, without looking at the WAL file. All of which was done not only by Trooper Garino, an independent expert named Jessica Hyde, which counsel has all of that, as well as the senior technical analyst from Cellbyte itself, a man named Mr. Whiffen. Counsel's had this report for months at this point. And essentially, Mr. Whiffen is essentially the person who creates the software that all of these experts are using.
Apparently, Mr. Lally thinks that nobody's going to be smart enough to Google that to fact check him. Turns out, the people who actually wrote the Cellbyte software were Israelis. I'm not even going to try and say those names, but you can see them right there on the screen. So, here's Mr. Lally misleading the court yet again. But I do digress.
And his definitive opinion indicated in his report is that Ms. McCabe conducted those searches at 6:23 and 6:24 in the morning. So I would agree with counsel that it's really no longer up for debate. I think we just disagree as to the conclusions of that. But based on the totality of the evidence, and what I would submit as the overwhelming evidence that was presented to this grand jury, all of these sort of individual parsing of stated malfeasance simply doesn't even come close to sustaining the burden under Odell.
Well, that comes down to interpretation, Mr. Lally. I'll leave you all with Melanie Little's interpretation, which varies wildly from Mr. Lally's. But at the end of the day, we all know why the judge is called Auntie Bev. And it isn't because Turtle Boy, Turtle Boy, Turtle Boy, Turtle Boy, Turtle Boy, Turtle Boy. Wink, wink. Anyway, here's Melanie Little giving her interpretation.
The federal investigation is not about finding who is responsible for Officer John O'Keefe's death. That's not what they are investigating. They are not trying to find a third-party culprit here. They are investigating the investigation. So perhaps Lally's not quite sure what the feds were investigating, but they're not out there looking to find out who did it. So this is a ridiculous argument. The Google searches. The Google search that Jen McCabe made at 2:27 a.m. did in fact happen. It did in fact happen, and that was confirmed by a Quantico-trained FBI agent who went over the data, and he confirms that 2:27 a.m. how to die in cold search actually did happen. And then the two searches at, I think, 6:24 and 6:27 also happened as well. We also learned that Sergeant Lank and Trooper Proctor's close ties to the families involved here were not disclosed to the grand jury. We know that Proctor told Yuri Buchanek about his close ties to Chris Albert prior to interviewing, to the both of them interviewing Chris Albert. Chris Albert, right? Yeah. We know that Julie Albert, Chris's wife, texted Michael Proctor's sister to tell Michael Proctor that after all of this was over, she was going to get him a thank you gift. And then in response, Michael Proctor said, tell her to get my wife a gift instead. We know that Trooper Michael Proctor, who is the lead investigator in this case, was going to have, about 2 weeks before this incident happened, was going to have Julie Albert babysit for his toddler. We know that an accident reconstruction expert was hired by the feds, an independent accident reconstructionist with 3 PhDs, who said John's injuries were not caused by a car, and a car did not hit John, and John was not hit by a car. This was an independent federal hire, somebody who has nothing to do with this case. We learned a lot about integrity and about what Mr. Yannetti thinks Michael Morrissey does not have in that area. And in fact, one law professor used Michael Morrissey's speech as an example to his law students how to not be a prosecutor. We learned that there was a conference call between a number of witnesses who testified in front of the federal grand jury, including Nicole Albert, Jen McCabe, Matt McCabe, Brian Albert, Lally, and a victim's advocate. A conference call took place prior to them testifying in front of the federal grand jury. We learned that the DA's office gave permission to Brian Higgins and Brian Albert to either dispose of or go ahead and get rid of your phones, destroy them. We know that 5 minutes before the 2:27 How Long to Die in Cold search that Jen McCabe's phone made, maybe she didn't make it, her phone made it. At 2:22 a.m., there was a call between Brian Higgins and Brian Albert when they both testified that they were asleep. And if that's not enough, we heard Lally say, the phone doesn't lie. The truth is in the phone. If that's not enough for you guys, I don't know what will be. I just can't. You can't make this up. You just can't make it up.
Essentially, the defendant, as the court is aware, doesn't challenge the grand jury presentation of the McCarthy grounds or probable cause standard. Defendant motions challenges under Odell. Odell essentially states dismissal of an indictment on impairment of the grand jury proceedings requires proof of 3 elements, as the court is well aware. One, that the Commonwealth knowingly or recklessly presented false or deceptive evidence to the grand jury. Secondly, that the evidence was presented for the purpose of obtaining an indictment. And 3, that the evidence probably influenced the grand jury's decision to indict.
Okay. And if that's the standard under Odell that we're arguing, I'll argue it for you right now. Number 1, that the Commonwealth knowingly and recklessly submitted false, deceptive evidence to the grand jury. Well, yeah, they did. They did when they had Proctor get up there and swear to tell the truth, and they did when they had Lank get up there and swear to tell the truth, and they claimed that they had no personal relationship with any of these people. That the evidence was presented for the purpose of obtaining an indictment. Well, yeah, that's why you have a grand jury. That is the purpose of a grand jury. Obviously, that's what the evidence was presented for, and that the evidence probably influenced the grand jury to indict. Well, yeah. These are troopers from Massachusetts State Police and police officers from Canton PD. Of course, we're going to believe them because they are the law. Of course, that's going to influence the grand jury to indict when a number of officers get up there and swear to tell the truth and they don't tell the truth. So there you go. There's your motion.